Hi, welcome everybody to the webinar on Buying a Business, Negotiating for Success. Thank you for joining us today. I'm going to pass over to Bex to do our intros.
So hi everyone, my name is Rebecca Smith and I'm an associate here at LegalVision in the corporate team. And I am joined today by my colleague Nina Vanderlaan, who is a senior associate also in our corporate team. So before we begin, a couple of quick housekeeping items. You will receive a recording and the slides in your email after this. If you have any questions that you haven't pre-submitted, please send them through into the question and answers box and we will try and answer them all at the end. And we would really appreciate if you could please complete the feedback survey after the webinar. So for the next 48 hours, you're also eligible for a free consultation with LegalVision to discuss how we can help your business. To take advantage of that consultation, please provide your contact details in the survey at the end of the webinar. Awesome. So onto today, we will be discussing types of business purchases, when to use an NDA or a non-disclosure agreement, preparing for and negotiating the terms of the purchase, documenting the agreement, the purpose of due diligence and how it can be used in the negotiation process, how to protect yourself from future risk, and how settlement works and the common pitfalls to avoid after settlement. Now I'm going to pass over to Nina, who will give you a quick overview on the types of business sales.
Thank you so much, Bex. So just before we kind of get into the nitty-gritty of how the process works, I thought it would be useful to just quickly outline how there are two key ways that you can approach a business sale, one of which is an asset sale and one of which is a share sale. So in a share sale, what's typically happening is that there's a company that owns the business and you are effectively stepping into the shoes of the existing shareholders. So they are selling their shares to you as a new owner. And as compared to an asset sale where you are purchasing the assets of the business. So in the share example, the shares are being transferred from previous owners, previous shareholders to you as the new shareholders of the business. And in an asset sale, the assets are being transferred from the company that owns them or the person that owns them to you as the new buyer. So for the purposes of this webinar, we're going to be mostly focusing on asset sales because those are the types of sales that we usually see day to day. And it's sort of more relevant to small business purchases. And it's relevant because the way that you're structuring the sale will impact on the sorts of things that you focus on, how you approach the negotiations, what you focus on in due diligence, as well as how you document the agreement and the sorts of terms that you'll be agreeing to. The other relevant consideration is what the size of the business is. So if you think about, the purchase of a business that's $100,000 versus $5 million, the scope of the research and the due diligence that you're going to be undertaking of the business is quite different. So throughout the course of this webinar, we're sort of going to be giving a high-level overview of business purchase process, negotiations and due diligence, but just bearing in mind that this is sort of tailored towards asset sales of smaller businesses, but every purchase is very specific to its terms. And so we would just really encourage you to book in for that free consultation if you want to talk about any sort of details that you're dealing with at a personal level, or, look into membership with us if you want any support with a business purchase as they come up. So the next thing I'm going to quickly talk about is NDAs. So an NDA stands for non-disclosure agreement. It's another term for a confidentiality agreement. And when would you use an NDA in the context of a business purchase? So there's different ways to approach it, but typically an NDA would be useful where you're starting to exchange information with the other party that might be considered to be commercially sensitive or confidential information, and you want to make sure you've got some protections in place to ensure that that information isn't going to be disclosed to any third parties. So in a situation where you're entering straight into an agreement or a term sheet, as we'll discuss later, those will contain confidentiality provisions, but we are not quite ready to get to that documentation stage, and you do want to start sharing some information to sort of assess the viability of the business and whether or not you want to proceed with the purchase. You can put an NDA in place to facilitate the sharing of that information. So in terms of the type of NDA you use, it can be a one-way one, so the obligations are only on one party, or mutual. So it all depends on which way the information is flowing as to what you use. And we just always recommend with NDAs they can be quite difficult to enforce if you think about, the harm is done once the information is leaked. So when you're using an NDA, just always make sure that you're communicating constantly, making it really clear to the other party when you are sharing confidential information and saying, just a reminder, this is subject to the NDA that we've signed. It's not to go any further than between the two of us and only to be used for the purpose of the business purchase at hand. Cool. So I'll now pass back over to Bex to talk about some negotiation strategies.
Wonderful. Thanks, Nina. So next steps is talking about preparing for negotiation and strategies around this. So the first point we're suggesting to do is doing your research and being prepared. So understand the business you're looking at, understand the ins and outs of it. What market is it operating in? Are there market conditions that will affect its success? And what or who are the competitors in the market that business is operating in? Understanding your leverage points. So are there external factors that might influence your negotiations? For example, any seller's pain points, or is there any motivation for the seller to sell quickly? And again, like we said, market conditions, again, are a really key leverage point. The next one would be deciding on your negotiation strategy. So what are you willing to negotiate on? What points are non-negotiable and which ones are you willing to bend a little bit on? Have a clear mind of this before you proceed with negotiating. The other thing to consider with strategy is the type of strategy. So are you going to approach it in a collaborative way where, you want to try and compromise with the other party and work together, or are you going to be a bit more competitive, so focusing on a win and taking a more hardline approach? As Nina kind of touched on, the type of the business, the size, and the interest from other parties might affect the strategy that you take, but generally speaking, a collaborative approach will achieve a better working relationship and therefore usually a better outcome. Another key strategy to consider, or something to consider in negotiation, is the building of rapport. So while you want to maintain a professional distance from the other party, you also want to create enough of a personal connection that you are building a rapport and creating a really open communication and dialogue with the other side. Finding common ground on minor issues that can be resolved or compromised can also really build towards that, because you want to work together, and being consistent with that communication. So using the same communication strategy, being really open, and being as clear as possible with what you're trying to relay to the other side. Another key part, which we often talk to clients a lot about, is managing your emotional aspects of negotiations. So one is understanding your own emotional triggers and trying to separate it from business decisions. It can be really hard. Buying a business is exciting, but obviously it needs to be financially viable and a smart decision to make, not just because you love the idea. It also can be an emotional time for a seller. So some of those concerns that they have might actually not be a business decision, but they're actually emotionally attached to something. So again, that communication piece is really key to understand where they're coming from and to try and, make a common ground. And then another point on that is with the emotion part is understand when it's appropriate for you to take a break or postpone a discussion to make sure you're making rational decisions rather than the decisions in the heat of the moment. Cultural considerations can also be really important in negotiations. So understanding different communication methods are more suitable for some contexts than others, and knowing when to adapt when required. And obviously part of that too is some cultures differ with the way that they deal with conflict and compromise. So again, just adapting as appropriate. And the final point on this piece is using silence and timing effectively. The age-old adage, silence can be golden, is key here. Don't feel like you need to talk the whole time. Pausing can be a really effective negotiation strategy. And it also allows time for others to process and respond. So try not to fill all of the empty space with noise. The other part of that is timing. So using timing, so setting clear deadlines can also help with creating momentum and creating a little bit of pressure. But again, that's part of being open and consistent and clear with communication, right? If your deadlines are clear, everyone can work to the same goal. The next point that we're going to talk about is negotiating the terms of the sale. So some terms are more negotiable than others. So example of terms that you can negotiate would be things like the purchase price, the timeframes for any in the contract, any conditions you want to include. So we really commonly see conditions like finance, due diligence, and leasing provisions. Whether there are any key employees that are going to be coming over with the business or need to be talked about or considered when talking about the business sale, and any restraints of trade that need to be put in place. So for example, as a buyer, you might go, well, actually, I don't want the vendor opening a competing business in the area for a certain amount of time. talking about the purchase price. The purchase price is obviously a really big one to negotiate. And independent valuation can be really key with assisting with attaining the price. And other key considerations that will affect the value will also include things like the financial performance history of the business, the market position, the customer base and relationships, the dependency on key personnel, and how the industry is faring in the economic climate. So as I said, like we talked, those things are obviously negotiable. So purchase price, payment terms, the conditions, due diligence, but things that often aren't negotiable are things like confidentiality, like Nina talked about. Most parties don't want to negotiate about what's confidential or not. It is or it isn't. Any regulation requirements, the warranties about ownership under the contract, and the authority to sell from the vendor. Now I'm going to pass back to Nina to talk about actually documenting the arrangement.
Thank you, Bex. So in terms of documenting the agreement, I'm going to talk about the option of using a term sheet as well as going straight to contract. So again, which route you go will be context specific for the business purchase that you're contemplating. I'll talk about the term sheet first. So the term sheet is basically a high-level document that you can use to capture the initial terms or the key terms of the deal that you're proposing to enter into. You'll see other terms, other names be used for this document, such as letter of intent or heads of agreement. They're all pretty much the same thing, with the intention that you use that document to settle on those key terms. So the terms that Bex sort of raised before are the ones that you would typically see in the term sheet. So again, the assets that are subject to the business sale, you would want to clarify what it is you're actually purchasing and if there's anything that's excluded from the sale. So sometimes we see, for example, businesses might have like certain vehicles or certain like phones or whatever, which are being used for the business, but are sort of more owned by the business owners in their personal capacity. So sometimes things like that might be carved out, or if you're just doing like a partial purchase, then you would just want to be really clear about what the assets are that are coming across. Obviously, yes, as Beck said, purchase price, employees, payment terms, those conditions. If you are wanting any assistance from the vendor in supporting you to make the transition of purchasing the business is something you might talk about. And you might also want to cover off what sort of timeframes you're both hoping to work for in terms of conditions being met and then settlement after those conditions are met. So the term sheet is usually a non-binding document. So that means that even though you're capturing what you intend the terms to be, those are not set in stone, and they will not be set in stone until such a time that you enter into a formal contract after the term sheet has been signed. However, with that, and even saying that, it can be a little bit tricky to move from that position sometimes. So you definitely don't want to just sort of put down whatever in the interest of progressing the negotiations. You do want to feel comfortable enough that what's captured in the term sheet reflects your intentions in respect of the deal at hand. But usually it's non-binding, other than some exceptions, such as you might agree to exclusivity in respect of the purchase of the business, which means that the vendor is agreeing that they won't enter into negotiations with any other potential buyers while you're continuing to sort of do your research on the business. And the confidentiality provisions, again, if they haven't already been captured in an NDA, those will be binding, and you'll usually specify that you're working within the bounds of New Zealand law, which is particularly relevant if you're dealing with an overseas purchaser or vendor. So to move on to documenting the actual agreement. So once you've firmed up the terms, whether that is between the discussions between the parties or by using the term sheet tool, you will enter into the contract stage. So that's the agreement for sale and purchase of a business. And who's responsible for preparing that? It can really be either party. The vendor obviously has the most knowledge of the business, so can be better placed to prepare that agreement. However, if you're thinking about it more from the perspective of a buyer making an offer for purchasing the business, the buyer will be coming with the conditions that they want to be attached to their offer, and so they can be better placed to prepare it from that perspective. In reality, what ends up happening is that one party will prepare a draft of the agreement, and then the other party will review that and provide their comments on any provisions that they don't consider to sort of reflect what they think is agreed. And again, we act for both sides regularly in terms of business sales, and we'll prepare these agreements for both sides. What we often see in practice with buyers is that we'll put the offer contract in place, and then the vendor will be responsible for providing the schedule of assets that are subject to the sale for the buyer to review and ensure that it aligns with their understanding of what it is they think that they're purchasing. So the sale and purchase agreement will capture all of the terms of the agreement. And so again, there's a bunch of negotiable ones, the key sort of terms of the deal, and then a lot of just standard legal protections that you would want to see in there, some of which can also be negotiated. In addition to what we've already covered off, you as a buyer would really want to see warranties from the vendor, and that's things like making sure that the financial statements and all the other information that you've relied on that's been provided by the vendor is accurate. You really want to make sure that you're receiving clear title to the assets so that these are not encumbered by any registered security interests that have been put in place by third parties. You would want warranties as to there being no undisclosed liabilities. So basically making sure you have a good understanding of all of the assets and liabilities of the business that you're taking on. You would want some warranties to ensure that the business has been conducted in accordance with any relevant laws or regulations, that all the contracts that are forming part of the business that you would be relying on to continue running the business are valid and can be assigned to you as the purchaser. And also that there's no pending litigation or disputes in respect of the business. Definitely not something you want to be involved with, or if you are, that at least you have your eyes open as to what you're taking on there. Some other common legal terms that we would normally include in these, or as a purchaser you would be wanting to have, are indemnities where possible. So the indemnities are basically the buyer saying that where certain promises or warranties are not met, that they will compensate you for those if after the fact. So it's an easier way to kind of get recourse, financial recourse, rather than having to actually prove that there's been a breach of contract or some harm or loss suffered to you as the purchaser. I've put personal covenanter there. So covenanter is another term for getting a personal guarantee. So where you're purchasing a business from a vendor, which is a company, you can often, or we would recommend that you request that, the key director or shareholder or multiple persons involved with the business also guarantee the obligations of the vendor under the agreement. And this is particularly useful where it might be that that company has only been used for the purposes of running this business, so therefore the company might be wound up after the purchase has been complete, and so then there won't be any entity for the purchaser to go after if something happens after you've taken on the business. So having that personal guarantee from some people in their individual capacity can be a really useful way to try to get some recourse down the line as well. And then purchase price adjustments. So this is basically looking at, you might have a fixed purchase price for the business, but then you might also say, and this could come up in due diligence, which we'll talk about shortly, we've noticed that the business is reliant on these key customers. We are paying this purchase price on the basis that these customers are staying with the business. If those customers end up leaving within a set period of time, then we will either claw back some of the purchase price, or what you might do is hold some of the purchase price in escrow until such a time that you've confirmed that all of these expectations around the business have been met. And if not, then the purchaser might end up holding on to those funds. So there's all sorts of different sort of legal levers and tools that you can use to make sure that the deal really reflects what you're expecting in terms of the business. And with all that in mind, we just really recommend that it's so important to make sure you have a appropriate M&A lawyer working with you when you are thinking about buying a business, and that they are either helping you to prepare the contract or review the one that you've been provided, just to make sure that you can be advised on the terms that are contained in there, to make sure you're understanding them properly, and also to make sure that everything's included that you're expecting. Okay, so I will now pass back to Bex to talk about due diligence.
Thanks, Nina. So as we've mentioned, a typical condition we see is a due diligence condition, which is a formal process where a buyer makes inquiries to validate representations and assumptions made by a seller about their business. So the due diligence process will assist the buyer to identify risks, determine the value of the business, and avoid any post-settlement surprises. So, loss of any key staff or customers, and as Nina said, identifying any unidentified risks and liabilities. And then also make sure that you review things like their financial records and their business operations, any key contracts, and also quite crucial is leases and any other legal documents. In terms of the timing and the process of due diligence, it can often begin prior to signing the term sheet. So it starts as soon as you start showing interest in the business, right? You start to figure out what's going on and understand the ins and outs of the business. But we usually see it continue through the sale process, depending on the complexity of the business and the level of the detail required for the due diligence. And we would normally see it documented as a formal condition in the agreement for the benefit of the buyer. So other key things to consider in due diligence are things like security interests, which for businesses are usually registered against the Personal Property Securities Register. So it's important to understand whether these will be able to be discharged before settlement, because you don't obviously want those liabilities to sit on the business going forward if they've should have been removed. As Nina said, any litigation searches, you want to know what's going on in terms of any potential litigation. You'll want to look at the employment contracts. So if you're taking over employees, what those terms look like and what you're agreeing to before you take it over. Any material contracts with customers and suppliers. And as I touched on before, any property leases. So that can be really crucial if the location of your business is really important to its success. But ultimately, you want to make sure that the big picture of the business, when factoring in its assets, liabilities, risk, and potential for growth, are aligned with that purchase price that you're willing to pay. And the due diligence stage will really, really hone that down for you. So the key thing to look at too in protecting the business value for future usage. So are the key client contracts locked in? So as Nina touched on, are they specific? Do they have specific terms? Are they able to be transferred via assignment or novation? You want to make sure that those key contracts are locked in place for a long time and they're not just going to end 30 days after settlement. And then another really important piece is the business's intellectual property. So what is the nature of the IP protection? Have they protected their brands? Is there trademarks in place? Are there patents? And who owns the IP? So it's really crucial to ensure that there's agreements in place that set out that any IP that's generated while employees or contractors are working for the business is transferred to the business. And we touched on key workers. So are there any key workers that you require to keep engaged after completion? And who is responsible for honouring the key employee entitlements? And how do you keep those employees motivated to stay and continue working with you rather than the old business owner? And as I touched on briefly, like location. Is location key for your business? What is the term left on the lease? Are there rights of renewal? Is this all satisfactory? Ensure that there are no secret clauses in those leases that talk about demolition or sale of the premises, which you could lose the premises for. And now the key thing is, will the lease be assigned, or is the landlord requiring a new lease to be entered as part of the business negotiation process? Now I'm going to hand back to Nina to keep talking about some more due diligence points.
Awesome. Thanks, Bex. So when you've conducted your due diligence, obviously the purpose of the due diligence is to identify any risks associated with the business and make sure you have a really clear picture of what's going on in the business to help you make an informed decision about your purchase. So you might have some findings that come out of your due diligence that you're able to utilize in terms of negotiating the terms of the agreement. And this can even be done, if you've already entered into a contract by way of variation if need be. So if the due diligence has revealed risks or liabilities in respect to the business, and that might be things like, equipment that needs repair or replacing that you didn't realize at the outset, if there are any sort of legal compliance issues, any key customer or supplier contracts that are due to expire, or any sort of undisclosed debts that you didn't realize at the front end, then these are the sorts of things that you can use to try to negotiate the agreement, and in particular the purchase price. So you'll be wanting to quantify those risks and liabilities into specific dollar amounts, and then use those amounts to either negotiate a lower purchase price or to structure in some protections like holdbacks, sort of just as I described earlier. In terms of how you present these red flags that you found in due diligence, you just want to come with a really clear plan and proposal. So present the findings with clear financial impact of what you expect that impact on the business to be from what you found. Use expert reports where appropriate to support your claims. link the price adjustment to the specific risks that you've identified, and propose structured solutions rather than always just price cuts. So just try and be prepared to work with the other side and negotiate to come to an outcome that everybody's going to be happy with. The other thing you might want to consider is negotiating additional warranties. So by way of example, as I mentioned, the due diligence might show up that the business has a high level of customer concentration, which means that the business is reliant on a small number of customers to generate a large amount of its revenue, which creates a real vulnerability in the business in the sense that if one of those customers were to leave, a large drop in revenue would occur. So when it comes to things like that, you could request a warranty from the business to say, all the contracts are valid. None of these key customers have given us any indication that they are thinking about leaving or reducing their level of business, that there's no disputes happening with key customers. And then you could also build in some further protections. Again, the earn out I was talking about before, we're holding this amount back until such a point in time in the future where we can see that these customers are in fact staying with the business, or we've generated X amount of revenue over that time. So, how to protect yourself from future risks? A few strategies here to avoid overpaying for a business. So it's really a summary of what we've been talking about. Make sure you understand the objectives of the seller. In situations where a seller might not be in a rush to try and sell a business, they might be really trying to stick to their guns and get a higher price than what the business is worth, whereas in other situations you might have a seller that's a bit more desperate to leave, in which case you might be able to get a lower price. But either way, kind of understanding that context will help you to make sure that you are reaching the appropriate price. Align with your strategy, do your due diligence, and negotiate where you can. We also recommend that you always seek tax advice with these sorts of matters in respect of the purchase price and any proposed earn-out provisions. This can be a complex area from an accounting and tax perspective. So the dream team is really having your legal on one side and having your tax accountant on the other side, and to make sure that you really have a full picture of what's going on there. And just a few points here for key steps for a successful business acquisition. Develop your strategy, thorough research, prepare a business plan and financial model, make sure you understand the past performance factors and whether or not those are going to, you can rely on those continuing in the future, and getting your legal advice. As I said, all the purchases are different. They're all very context and industry specific. So the terms that you'll want to be focusing on and including will differ. And so we just always say, bring a lawyer on board, make sure that you're doing it properly. All right, back over to you, Bex.
Thanks, Nina. So now we're at the fun part, so settlement. So this is often called completion, and usually the agreement will set out a target settlement date, and sometimes like a latest date that settlement can occur before the agreement terminates. And settlement will typically occur on the later of the target settlement date and the date after all the conditions have been completed to the satisfaction of the buyer. So as we've touched on a few times, conditions precedent are the conditions that are set out in the agreement that must be satisfied or waived before a settlement can take place. And they can conclude, as we said, due diligence, obtaining consent from third parties, for example, to transfer a contract, obtaining finance for the purchase, the seller securing the release of security assets over the assets of the business, obtaining landlord consent for the assignment of the lease, conversations around employees, and entering into new employment agreements. The conditions are usually for the benefit of the buyer. So again, your lawyers and your financial advisors will typically run settlement on that basis. And usually your lawyer will typically prepare a settlement checklist, which will detail all the deliverables in the transaction document that need to be checked off. So all those conditions that need to be met before, we push go on settlement day. And as settlement gets closer, the parties usually will have more frequent check-ins with each other to make sure that everything's on track and everything's getting ticked along as we go. So on settlement day itself, at this point, most of the hard work is done. Usually all the conditions are satisfied at this point, but if there are any ancillary documents to be provided upon settlement, such as signed employment agreements, confirmation of security discharges, or assignments of the lease, they may be provided on the day of settlement. Sometimes there is a settlement call between all the parties to run through the settlement checklist, but if things are, it's a smaller transaction and things have been relatively straightforward, then sometimes this is just done via email to confirm everyone's ready to go. So once parties have confirmed they're ready to complete or settle, the buyer will transfer any agreed upfront payment to the seller, and the seller will then confirm receipt. Following this, the seller will then need to deliver any required documents to the buyer, so such as company records, keys to the premises, passwords, and any access to other accounts if that hasn't already been done. Nina, I'll pass it back to you now just to touch on common pitfalls after completion.
Thank you, Bex. So once settlement's done, time to get stuck in and enjoy running the new business. So there are some common pitfalls that we see that you want to try and avoid to help ensure the success of your new business. So these are things like failing to properly transition key relationships, poor handover of operational knowledge, misalignment on earnout calculations, employee retention issues, customer-supplier relationship breakdown, breach of restraint provisions, integration challenges, and dealing with unexpected liabilities. I'm going to straight away jump to avoiding these pitfalls so we can focus on the positive. So I think the key thing is communication. Throughout, as we've kind of touched on a number of times, you want to make sure that you've got those lines of communication open. Everybody's been as transparent as possible about what it is they're seeking to achieve, and making sure that you're clear on the terms that you're agreeing, and then making sure that those terms are accurately reflected in the documentation in respect of the purchase. So ensuring that you've done all of that at the front end, it just really reduces the scope for any misunderstanding or ambiguity to arise down the line. So really can't emphasize that enough. The other recommendation is to just make sure you're doing a really thorough due diligence. This just really helps to avoid the risk of surprises post-settlement. So in terms of any unexpected liabilities, hopefully there are none. If you've done a thorough due diligence, you've got a good understanding of what's in the business, there are not going to be any surprises down the line. As we've already said, it's so easy to get excited about taking on a new venture, but we just really suggest slow it down, avoid rushing or taking shortcuts to make sure that you're doing it properly to reduce the risk of things going awry down the track. And in terms of, the operational handover, integration challenges, all those sorts of things, make sure you're working with the vendor to prepare detailed handover lists, engage in that transition planning together, put customer and employee communication plans in place. So not only is communication between you and the vendor really important, but also communication with the existing customers, existing suppliers, and employees. Get them all on board with what you're proposing. Make sure they know who you are coming into the business. They want to work with you. They want to work for you. And hopefully, they'll all stick with you so that you can continue running that business in a successful manner. And then finally, just, having specific dispute resolutions in place so that if something does go wrong, at least you've got a guide there that you can turn to say, okay, this is something we need to work through, and we've already put this in place to say this is how we're going to do it. For example, we're going to go to mediation first, bring in a third party, help us to work through this and come to a solution that we can, both move forward with. Amazing. So that brings us to the end of the main part of the webinar. Thank you very much for your attention. We've got a link here to our due diligence guide. You might find that useful. You can either download that by scanning the QR code there on the slide, or from the resources tab. You might also be interested in our upcoming event about managing high volume work streams in-house. This webinar is going to be held at midday on Thursday, the 19th of November. You can register on the LegalVision events page shown there. So we're going to go into Q&A in a moment, so please send through any last minute questions you might have. While we wait for those to come through, we'll just take a moment to talk to you about LegalVision's membership. So our membership offers businesses unlimited access to our full team of more than 100 specialist commercial lawyers. We can provide you with all of your business as usual legal needs. For a fixed monthly fee, you'll not only receive cost certainty, but all-inclusive benefits such as unlimited document drafting and reviewing, unlimited legal advice consultations, unlimited trademark registrations, and more. If you want to know more about our offering, you can have a look at our website. There's some good content on our YouTube channel as well. So please do that if you're interested. And in addition, again, if you'd like to talk to one of our team about your specific business purchase needs or otherwise how our membership might help you, please request a free consultation when the survey appears at the end of this webinar. All right. So, Bex, would you like to kick Q&A off?
Awesome. Thanks, Nina. So I've had some really good questions come through beforehand. So let's just touch on some of those first. So the first one I will answer is, what are the top 5 reasons why a negotiation will not be accepted on both the buyer and seller sides? And conversely, what are the 5 biggest mistakes buyers make in a negotiation you've seen this year? I mean, the biggest reasons negotiations fail is that parties can't agree on commercial terms, right? Or conditions can't be satisfied. So that's often when a third party is involved. So we've seen ones where the landlord won't agree to the sum of the lease, or a bank just won't come to the party for finance. Crucially, in the M&A space, negotiation is not a combative process. So it's more about an overriding attitude of all the parties and how they should be taking it, and also their legal team. Everyone wants an outcome here and wants the sale going through. So compromising is key, but obviously making sure both parties get the end result that they want. Nina, I'll give this one to you. So we've had a question: how many acquisitions have you and your team been involved in, and whether they have been part vendor finance or 100% vendor finance, and what that looks like in your experience?
Yeah, cool. Thanks, Bex. Yeah, look, business sales is kind of some of our bread and butter, business as usual type work. So we support with lots of business acquisitions all the time of sort of different sizes and approaches. Vendor finance is a common feature of the transactions that we see, and I would say especially more so as we're kind of entering this economy where there's not as much money flowing around, there's potentially not as much certainty around the success of a business after purchase. And so from that perspective, vendor financing is becoming a bit more common. It would be quite rare to see one where you've got 100% vendor finance. Usually vendors want to see at least some level of financial commitment into the business, some cash in hand to say that, you're serious about what's happening and you've got some skin in the game. So we wouldn't usually see that, but having sort of part vendor finance and part cash is quite common. If you've got any, again, more sort of specific details about what that looks like, please do reach out and we can talk about that in more detail. I'll just finish that off by saying, usually what that looks like in terms of documentation is you would have your sale and purchase agreement on one side, and then associated with it would be a term loan agreement, which would kind of set out the terms of how much money is being financed by the vendor and how that is to be repaid, whether there's any interest or those sorts of things. Cool. Do you want to take the next one, Bex?
Yeah. So we've had one say, well, what happens to my employees? And I think we've touched on this briefly through the webinar, but in an asset sale, employees may or may not transfer depending on the agreement. So again, that's another point of negotiation, what you do in that space. But in a share sale, which we haven't really touched on, but in a share sale, they usually just continue because the business hasn't changed apart from who owns the shares. So that's usually how it works with employees. But we're happy to go into that in more detail if you've got a specific example of how you want that to look. Nina, I've got this one for you. Can you talk through negotiating down the asking price when goodwill appears unreasonable, where the sales are on a decline, but the potential the seller is basing goodwill on is based on historical successes, not current sales?
Yeah, good question. Quite specific, obviously, to the business you're probably looking at. Generally, like the way the breakdown of the purchase price looks is you would have a total purchase price that you've agreed on, and then that would be broken down into the tangible assets in the business. Each asset of the business would have a specific amount attributed to it. So that's sort of a fixed amount, if you will. And then the difference between the tangible assets and the stock and the total purchase price is your intangible assets, i.e. your goodwill. And so ultimately it's a negotiation, right? Between you're trying to get to the sweet point, which is the lowest that the vendor is willing to accept and the highest the buyer is willing to pay. And in terms of, as you're saying, with looking at historical successes, it's absolutely valid to point that out to them and to come with a proposal to say, well, this is the reason why we don't think that that's an appropriate amount. And sort of say, what we're seeing going forward is that, X is a more appropriate revenue that to expect compared to what you've had in the past, and these are the reasons why. But at the end of the day, you can say as much as you like, but if the vendor's not willing to come down in price, it's up to the purchaser to just think through whether or not the business, whether you see the value in it at the price that the vendor is asking. So hopefully that's helpful. Bex, do you want to take another one?
Yeah, no, that was good, Nina. And again, it's another one of those ones. If it's a specific example, please feel free to get in touch and we can spitball that a bit further with you. In your opinion, is now a good time to buy or sell a business? This is a tricky one. It's a good question, and it's a tricky one because it really does depend on the business you're looking to buy, but also your own financial position. So is the business struggling in the current climate, or is it thriving? Do you need finance? And obviously, interest rates have been higher, and is that going to make it viable to buy the business at the moment? And some businesses are hurting, so it could be a good time to pick one up. But again, like if there's one you're looking at and you want to talk about it, that's something we can discuss. But it's one of those things that really depends on what market you're buying in and what kind of business you're buying, because in all parts of the economic cycle, some businesses do better than others. So it's a case-by-case question. We've had one that wanted to ask about the services we provide, so that's great. We will provide the presentation afterwards, and we'll provide, there's obviously that free consult too. There's a question here, Nina. 3 founders and 1 has majority shares and final say. How should the company be structured to give the other 2 a meaningful say?
Yes, thank you, Bex. And I might actually just link my answer into another question which has come up, which is, I have a key employee wanting to buy into my business. Any advice on that? Yes, both of those questions are sort of outside the scope of this webinar, and speak a little bit more to how you would be structuring a company to buy the business. When we are supporting clients with buying businesses, talking about the structure that you put in place to own the business that you're buying is almost always part of the support that we provide. Usually, as I said, sorry, this is outside the scope really, but usually, you would set up a company to make sure that you're not buying a business in your personal name, so you're protecting yourself from personal liability. And then in terms of, you would be looking at the shareholders and directors that you have. So yeah, it's a separate thing. Again, feel free to book at a consult. We can dive into that more.
Yeah, cool. Well, that is all of the questions that we have for today, which is cool. So thank you for all your questions. That was really great. And as we've both touched on repeatedly, if there's something you want to discuss in more detail, please just book at a call with us. We're happy to chat and go from there. We would really appreciate if you wanted to have that chat to submit your details in the survey at the end. And then, as I said, we can assist with the questions we didn't answer, or you can learn more about our membership. While this is a free webinar, we do value feedback about what's gone well and what you didn't like and what else you'd like to learn about. So we'd really appreciate if you could please complete the 30-second survey at the end. Thanks again for joining us, and we hope you have a great rest of your day.